This is Paul Turner, the immigration barrister at Imperium Chambers. Today, fresh claims, judicial reviews and the importance of the best quality evidence you can put. I had a JR in the upper tribunal recently which sadly did not meet with success, so on the face of it, it ought to perhaps have done in theory. It was a fresh claim brought under paragraph 353 of the immigration rules, which has a number of elements. Is the new claim significantly different to the old one? And does it enjoy a reasonable prospect of success before a first-tier judge? Unlike certification cases where the applicant only has to show that the case is not hopeless, the test is the usual one in JR of rationality. In this case, and the reason why I thought that the case had some prospects of success, the first claim was based upon private life. The client had only been in the United Kingdom for a couple of years. It wasn't going to go anywhere. The new claim was based upon marriage to a British citizen that at the time they had only been married religiously. Subsequently they had married lawfully and the partner had met the maintenance requirements. The Home Office in response attacked the decision not on the basis that it was different but on the lack of evidence. Now, judicial review is a remedy of last resort, not for putting in new evidence. However, new evidence and very good evidence at that have been submitted to the court, i.e. the wedding certificate, very detailed statements. The judge was troubled, but I perceived that things were not going to go my way and I could tell why. It was the new evidence. The Home Office brought up, and as they always do, that it was always open to the applicant to make a further fresh claim. The judge dismissed the application as a fresh claim, whilst on a dramatically different basis, was unsupported by nothing more than a short statement, even though he had been given more detailed statements to look at, but due to the rules under judicial review, he wasn't able to have regard to them in making the decision. In dismissing the application, the judge stated that, and I could almost tell from the look on his face, what he was going to say was that they could make a further application backed up with new and further evidence. Unfortunately, this is not the first time that I have seen this happen. What therefore is the answer? Well, in my view, even if you have a case which is dramatically different to the first case, please put in as much evidence with the application as possible. In a marriage case, put in representations, detailed, facts, law, immigration history, statements with as much detail as possible, evidence of the relationship, marriage certificate's a good one, photographs from holidays if you've been together, not in the same clothes though, pages from Facebook as they are usually date, location and timestamp, utility bill, show you live together, and of course that you meet the requirements of Appendix FM, such as that you earn enough money, accommodation, i.e. that you live in a house which can accommodate you and your partner and or family comfortably. It might be that you're home and you can live there comfortably, but who knows if it's Buckingham Palace or a tiny studio flat that you share with 15 other residents. English language requirements, certificates, qualifications. If you have to pass the Life in the UK test, pass it, produce it, and generally any other evidence to show that you've integrated into the United Kingdom. And also, and this is often missed, if you're making an application in country as opposed to going home, you will need to show that there are insurmountable obstacles to you returning to life abroad. Simply not liking the food or the weather is too hot or too cold, it's not going to be good enough. I did win a case on the basis that India was dusty, but that was only part of the evidence. Finally, while you can say as much as possible about why you might not want to live in the other country, such as you don't get on with your relatives, objective proof that you cannot for religious or health, see the dust, reasons ought to be produced. If you follow the above advice, you will have covered why your application is different and, more importantly, why the evidence should allow or could allow a different judge to allow the appeal. If you are thinking about making an application, remember that simply saying something does not mean it's going to be believed by the Home Office. The Home Office tend not to believe anything, even if it's put in front of them, in my experience, given the number of refusals, or that the court will accept it without objective, and the better the objective proof and the more the objective proof, the better. In my opinion, and I've been doing this for a while now, the The more work that you put in at the beginning, the more evidence that you put in at the beginning, the better the lawyer you consult at the beginning, the better the chances of success you will have if you're making a fresh claim, or indeed if you're making any claim whatsoever. The less you put in at the beginning, hoping that you can make up for it later, may cost you more in the long run, either in having to make a further fresh claim, and if it's a human rights claim, that will mean you will have to pay for another set of Home Office fees, and they are not cheap. And if it's an asylum claim, the Home Office may take it against you that you could have raised these issues or this evidence earlier. So more earlier, better chance of success. If you have an immigration problem, if anyone in your family has an immigration problem, or you're just interested in immigration, please get in touch with me, Paul Turner, the immigration barrister at Imperium Chambers, on 0207 242 3488, or clerks at imperiumchambers.co.uk, or my website, theimmigration.barrister.co.uk. This has just been a very short broadcast, just given the frustration that I felt, given that had this other application been put together in more detail, it would almost certainly have won. But that's my opinion. I may well have been wrong, and it may well have lost anyway. Anyway, thank you very much for watching. This is Paul Turner, the immigration barrister at Imperium Chambers.